in. Oh, Priscilla, you're so smart. Thank you. Okay. Casey, you want to go ahead?
I will. Hello, everyone. Welcome to the webinar. I want to make sure that everyone is able to have all of the interpretation services that we have set up. I'm going to ask that you look at the bottom of your Zoom screen. You should see a globe and it says interpretation underneath. The globe is next to the reactions button. It has a little smiley face. And if you click on the globe that says interpretation, you can see there is an English channel and a Spanish channel. If you are an English speaker, please listen in the English channel by highlighting the English channel in blue and clicking it. If you are a Spanish speaker, please highlight the Spanish channel in blue and select it by clicking on it. If you would like for me to repeat the instructions, please let me know and I will work to put them in the chat so that they're available to everyone.
Desiree?
Sorry. Buenas tardes, hola, bienvenidos a todos al seminario web. Hoy todo el mundo puede tener una interpretación. Tenemos el canal en inglés y otro en español. En la parte inferior de la pantalla de Zoom hay las partes de interpretación. Entonces, hay el globo en azul donde pone inglés y después el otro pone en español. Para escuchar en inglés, en el canal de inglés, resalte el canal inglés en azul. Y para el español también lo mismo, pone en español y resalten en azul y hagan clic en el español para poder escuchar este seminario web en español. Si quieren que repitamos estas instrucciones, díganlo y lo haremos.
And Mike, you should be good to go now.
Okay, thanks, Kaylee. Good afternoon and welcome to today's presentation on employment, know your rights. Today's webinar is funded by a grant from the Connecticut Developmental Disabilities Council. My name is Mike Wilby. I'm the Strategic Partnerships Manager at Disability Rights Connecticut and will be today's facilitator. My pronouns are he and him. I'm a Black male. I have on black rimmed glasses and I'm wearing a white shirt with a multicolored tie and black pants. Before we get started, I would like to discuss a few housekeeping items. If you have a question or comment, please use the raise your hand feature and you will be unmuted by the moderator. It can be found in the reactions icon at the bottom of your screen. Please remember to introduce yourself before you speak. There will be real-time captioning in English. There will also be live captioning and interpreters provided in the following languages: American Sign Language and Spanish. Make sure you're in speaker view. If you experience any difficulties accessing any of these accommodations, please put a note in the chat and we will respond as soon as possible. Finally, if you have a general question, please send it to the chat box as well and we will try to respond to it. I would like to begin today's presentation with the land acknowledgement. For those who are not familiar with that, a land acknowledgement is a formal statement that recognizes and respects Native peoples as traditional stewards of lands. The statement highlights the enduring relationship between Native peoples and their traditional territories. The statement that I'm about to read comes from the University of Connecticut's Native American Cultural Programs. By acknowledging that the land on which we gather is the territory of the Mohegan, Mashantucket Pequot, Eastern Pequot, Scotticoke, Golden Hill Pagaset, Nipmunk, and Lenape peoples who have stewarded this land throughout the generations. We thank them for their strength and resilience in protecting this land and aspire to uphold our responsibilities according to their example. Thank you. Our speakers and presentations for this afternoon include Deborah Dorfman, Executive Director and Attorney for Disability Rights Connecticut, Kathy Flaherty, Executive Director at Connecticut Legal Rights Project. Debbie and Kathy will be discussing Title I of the American Disabilities Act, along with the right to be free from employment discrimination based on disability, the right to receive reasonable accommodations, and how to file a complaint with Equal Employment Opportunity Commission, or EEOC, and the Commission on Human Rights and Opportunities, CHRO. After Debbie and Kathy's presentation, we will take a 5-minute break, and then we will start up again with our final presenter, Aaron Choquette, who is the Chief Operating Officer and General Counsel at Connecticut Paid Leave. Aaron will be discussing the new Connecticut Family Leave Law. Finally, we will take some time for questions and answers. At this time, I would like to turn things over to our first presenter, Executive Director and Attorney for Disability Rights Connecticut, Debbie Dorfman. Debbie?
Thank you so much, Mike. Welcome, everybody. We're really happy to have you here today. As Mike said, our colleague Kathy Flaherty and I are going to discuss with you your rights under the Americans with Disabilities Act and state anti-discrimination law. And so I will now turn it over to Kathy to get it started. Thank you.
Thanks, Deb. This is Kathy. Can you please advance to the next slide? So we're going to be talking about 2 laws today. The first is Title I of the Americans with Disabilities Act, which is a federal law of which we're celebrating its 32nd anniversary this year. It was enacted in 1990, and it's illegal for employers to discriminate against a person who has a severe disability and is qualified for their job or the job they're applying for and is able to perform the specified duties of the job either with or without reasonable accommodations. We're going to talk a little bit more about what each of those terms mean, but the thing that's most important that I always remind people of is that those ands are important. Having a disability is not like having a magic wand you can wave to protect yourself from discrimination if you're not qualified for the job or that you can't perform the job duties, even if you're given reasonable accommodations. The federal law protects employers who have 15 or more employees. We have a state law equivalent that protects companies where there are 3 or more employees. So I always tell people, if it's just you and the boss, hopefully your boss respects you enough, because you won't have the ability to use the law to help you, but they'll give you what you need. And if you're self-employed, take care of yourself and give yourself what you need to do to work. The thing that's important to know is that you do not have to be a US citizen to be covered by the Americans with Disabilities Act. It actually protects disabled workers, whether or not they're citizens, but of course you want to be somebody who has legal authority to work in the country before you file a complaint. And now next slide, and I'll turn it over to Deb.
Thanks, Kathy. So the ADA, we'll start out talking about that, which again is the federal anti-discrimination law, prohibits discrimination in all employment practices. And so that's really broad. It's not just discrimination in everyday workplace, but it includes things like a job application procedure, hiring, firing, whether a person gets a promotion, compensation, so training, and other terms or conditions of a person's employment. It also applies to the recruitment process, the including job advertisements and things like tenure, meaning how long somebody is staying in a job, or layoffs, or other benefits, and any type of employment related activity. So it's very, very broad. And now I will turn it back to Kathy.
And to the interpreters, this is Kathy. We will be going back and forth this first few slides. Discrimination, most people think of as unequal treatment. So there are 2 ways an employer can discriminate against an employee under the ADA. First is if they don't treat an employee equally, an employee with a disability equally, the same way they treat an employee without a disability. However, sometimes employees with disabilities ask to be treated differently, and that's what a reasonable accommodation is. So it can also be discrimination if an employer denies those reasonable accommodations to a qualified individual with a disability. Next slide, and I'll turn it over to Deb.
Thanks, Kathy. So you may be wondering, so what does disability mean under the Americans with Disabilities Act? And this is really important because when you're trying to figure out whether or not you have a right to a reasonable accommodation, you have to think about whether or not you are a person with a disability as the law defines that. So there's different ways in which under the Americans with Disabilities Act that people are considered to have a disability. So one way is if the person has a current disability or has a history of a disability, and that can be a physical or mental impairment, and those are words that are coming from the statute. Those aren't words that I'm making up, and that impairment substantially limits one or more major life activity. So you may be wondering, well, what is a major life activity? And that could be anything from walking, breathing, thinking, eating, sleeping. So it's really, when you think about it, it's what you do in your everyday life, what we all do in our everyday lives. And so the question is whether or not the physical or mental impairment substantially limits one or more of those types of things. Another way in which a person is considered to have a disability under the ADA is if they're regarded as having an impairment. So if somebody thinks that a person or says that a person has a particular impairment and they're being regarded as having that impairment, then that is considered a disability under the ADA as well. It should be noted that some episodic impairments might not be covered by the ADA. However, you know, people who, for example, may have a mental health disability, and that mental health disability does substantially limit one or more life activities, that will be covered under the ADA. So it's just important to look at your own individual situation and consider whether or not you fit this definition. And if you have questions, you can always ask, contact the RCT to find out, get some assistance. So I will now turn it back to Kathy, and next slide, please.
This is Kathy. So the question becomes, what does it mean for an individual to be qualified? Because remember, it's not enough to have a disability or be perceived as having a disability. You also need to be qualified for the job. And what that means is that the person has the education, employment experience, skills, or licenses that the employer requires for the position, and that the person is able to perform the essential functions, those are specific job duties, of the job, either with or without the help of a reasonable accommodation. An employer can't refuse to hire, promote, or otherwise discriminate against a person with a disability because their disability prevents them from performing duties that are not essential to the job. One example I always use for this is most office jobs say something about being able to occasionally lift 25 pounds, and that's the box of copy paper. And I always say, if you work in an office, that's really not going to be a duty that's essential to the job. So if you can't lift, that shouldn't be a barrier. But if you're applying for a job at an Amazon warehouse where all you're doing is moving boxes all day long, if you can't move boxes, even with an accommodation, you're not going to be qualified for the job because you're not able to perform that essential duty. I'll turn back over to Deb in the next slide.
Thanks, Kathy. So I want to talk a little bit now about what a reasonable accommodation is and what it's not. So what a reasonable accommodation is any sort of change that would enable a person who is qualified. And remember that Kathy just explained what, you know, who a qualified individual with a disability is. But an accommodation is any sort of change that would enable a qualified person with a disability to do things like apply for a job or to perform the essential functions of the job once they get the job. So, for example, somebody might need a change in like the schedule for a job, and that may or may not be reasonable. And it really depends on what the job requires. And this goes back to a little bit what Kathy was talking about in terms of what would be a reasonable. So, for example, if somebody needs to work in an office and they're just doing paperwork in the office, and the person needs to, have doctor's appointments or have some sort of medical treatment in the morning, it would not necessarily be an unreasonable thing to ask for a modified schedule so you could start your work a little bit later. It might also, another example might be a person may need additional breaks. So instead of having 2 10-minute breaks and half an hour, they may need additional breaks. That doesn't mean that they would get to take more time off than somebody else and basically be compensated. Well, sorry, I'll just say that you may be entitled to get additional breaks if necessary. Some accommodations, though, are not reasonable, and when they're not reasonable, that is because the accommodation would somehow cause an undue hardship for the employer. So, for example, if the accommodation requested was very expensive in order to implement, or would cost the business or employer quite a bit of money, or have some other economic impact. And so with that, I'll turn it back to Kathy.
Thanks, Deb. This is Kathy. And just before I really start talking about what's on the next slide, I think one kind of accommodation that a lot of people asked for years before we had the pandemic was being able to work remotely. And very often we were told, no, that's not possible. It's too expensive. It's a fundamental alteration. We can't possibly do our work that way. But when we had to do it to keep everybody safe, we were able to pivot to that. So it will be interesting to see if, because I think we're seeing employers already saying to people with disabilities, no, we can't allow you to do that anymore. I want to talk, and this will stay with me for a bit now, is talking about you might be wondering, what is this ADAAA? That's the Americans with Disabilities Amendments Act, which whenever we are talking about the ADA now, that's the law that we're talking about. Because if you are old enough to remember Schoolhouse Rock, Congress passes those bills on Capitol Hill. The executive branch enforces the law, but the courts interpret the law. And the way these cases were getting, working through the legal system is people were losing their cases, and people who were qualified individuals with a disability were not getting the protection of the law because the US Supreme Court cases interpreted the meaning of disability very narrowly. And so what would happen is that the people who brought these cases, called the plaintiffs, they were losing because the courts decided that they weren't really disabled. So the cases really never got to the issue of whether discrimination was taking place. Next slide. So Deb talked a little bit about what major life activities are, and the current definition is very, very broad because it's all those activities: seeing, hearing, eating, sleeping, walking, learning, concentrating. But it also talks about major bodily functions, including but not limited to, which means this isn't an exclusive list. Functions of the immune system, normal cell growth, so cancer is a disability under the ADA, digestive, bowel, Crohn's, IBS, disabilities under the ADA, bladder, neurological, brain, respiratory, so asthma, disability under the ADA, circulatory, endocrine, reproductive functions. Long COVID, disability, may be considered a disability under the ADA. And other life activities, if you didn't think that list was long enough and you thought of something else, that could also be considered major. And a disability might exist even if only one of those major life activities is limited. Next slide. And again, when the court was interpreting these cases and looking at individual plaintiffs' issues, they were ruling that basically people didn't win because they weren't disabled, considered disabled by the court. And Congress said, we need both the Equal Employment Opportunity Commission and the Supreme Court to interpret the phrase substantially limits more generously. And they just flat out told them, you need to be more generous. Next slide. The last thing I want to talk about is what are called mitigating measures. One mitigating measure for a disability, eyeglasses. Okay. And the court, the new version of the law, the ADAAA, says that any mitigation measures except for ordinary eyeglasses or contact lenses does not get taken into account when you're considering whether a physical or a mental impairment substantially limits a major life activity. One of the big cases was about an airline pilot. Commercial airline pilots are not allowed to wear glasses. And basically what happens is, what the court was saying is, if you use any of those mitigating measures, we're not going to consider you disabled. Congress said that's not what we meant. So now I want to turn it back over to Debbie.
Thanks, Kathy. So earlier, I was talking about what is a reasonable accommodation and, we talked about what's not, and we talked about when something is an undue burden. And that's when a person can be denied their accommodation, and they may not then be able to have what they need to work. However, there are other reasons why an employer may refuse to provide, to hire somebody or retain somebody with a disability who has a disability under the ADA. That situation is when the person is considered to be a quote unquote direct threat to the employer or to their business or to the public, because of the person has their disability poses a significant risk of substantial harm to the health and safety of themselves or to others that could not be reduced or eliminated as a result of a reasonable accommodation. And so what's really important to understand here is that an employer cannot say, well, I think this person might be, a direct threat, without actually having, there has to be a significant risk, and there has to be an individual assessment of each person's situation to determine whether or not there can be a reasonable accommodation that would eliminate or reduce the threat. And so, it's not something that an employer can just look at somebody or hear something that somebody says and just make that decision like that. They have to really do a very specific individual assessment and really determine that there's nothing that they could do to eliminate the risk. And that's really, really important, because a lot of times people with disabilities are the recipients of discrimination, whether intentional or not, sometimes because perhaps of the effects that the disability has on the person in how they speak, perhaps, or how they, walk, any number of things that lead people to impose discrimination on people with disabilities, and sometimes improperly believe that a person is dangerous. So this analysis is really important to understand. Next slide, please. The other thing that is important to understand about the reasonable accommodation process is that if you are a person with a disability and you request a reasonable accommodation, and your employer, or if you're an applicant, your prospective employer says no, and says, I'm sorry, the request you made, for example, is too expensive. We can't afford that, or causes some undue hardship to them. They can't just say, well, that's too bad, sorry, goodbye. They have to do something which we call going through the interactive process in order to try to find a mutually agreed upon accommodation. And that interactive process should be face-to-face, ideally in person if possible, but that's not always possible. And so if not, it should be done over video. And in fact, the interactive process, if a person needs an accommodation going through that process, that needs to be provided. But that there needs to be this process, and both the employer and the applicant or the employee with the disability have to participate in good faith. And if the employer does not go through the interactive process and just summarily refuses to provide the requested accommodation, then that is really a violation of the Americans with Disabilities Act. It's also really important to understand, though, if you're the person with the disability and you're asking for the accommodation and the employer says no, and you refuse to go through the interactive process, you may then have difficulty if you want to file a complaint or a lawsuit. You may have a lot of difficulty winning your case. So it's really important that both the employer and the employee go through this process. Next slide, please. So what happens if you are denied a reasonable accommodation, or you are otherwise discriminated against, or you believe that you were discriminated against by your employer or by a potential employer? And I'll just say that discrimination under the ADA doesn't require intent. You don't have to show that the employer intended to discriminate against you. It could be that the employer made a mistake, but discriminated nevertheless, inappropriately denied a reasonable accommodation request, or it could be an intentional act where they said, I don't want anybody here who has a disability because that'll make my business look bad or something like that. Either way, you have a number of options. One of the things that you can do is you can file an administrative complaint with the Equal Employment Opportunities Commission. It's otherwise known as the EEOC, and that is operated by the federal government. Or you can file a complaint with the Connecticut Commission on Human Rights and Opportunities, which is known as CHRO, and that's here in the state of Connecticut. You should understand that before you can file a lawsuit against an employer or a prospective employer for employment discrimination, you must file an administrative complaint either with the EEOC or with CHRO, because that is a requirement. We call that exhausting your administrative remedies, but you must do that. Next slide, please. And if you're going to file with the EEOC, and remember that's the federal government, then you have to generally file your complaints within 180 days of the date that the alleged discrimination occurred. And it's very, very important that you not miss that deadline. And so if you feel like your rights have been violated, I really strongly encourage you to file a complaint as soon as possible, because while 180 days feels like a long time, it's really not. Time goes by, and people sometimes miss deadlines. It's really also important that if you can, try to consult with an attorney about the deadline. But again, most complaints generally have to be filed within 180 days with the EEOC. And in the PowerPoint here, we have a link to the EEOC's website where it tells you how to file a complaint and what the process is like. And we can make the PowerPoint available to all participants today. And last thing I want to also let you know is that you can also file a complaint along with the EEOC. You can also file a complaint with the United States Department of Justice if you feel like your rights to be free from disability discrimination in employment have been violated. And so there is a link here also in the PowerPoint that you can use to get the information about how you can file the complaint with the Department of Justice. One thing I want to say is that filing a complaint with the Department of Justice, however, does not equal filing a complaint with the EEOC. So if you feel like you may want to file a lawsuit, you're welcome to file a complaint with the Department of Justice, and that's fine. But if you also feel like you might want to file a lawsuit, even if you don't know for sure, you still need to file an administrative complaint either with the EEOC or with CHRO. So, just filing with the Department of Justice is not enough. And with that, I'm going to turn this over back to Kathy so she can talk to you about filing complaints in the state of Connecticut.
Thanks, Deb. This is Kathy. This is our last slide, and then we'll be going to a break. But to file a complaint with the Connecticut Commission on Human Rights and Opportunities, which we fondly call the CHRO, those complaints must generally be filed within 300 days. That is a weird amount of time. It is about 10 months, but not necessarily if you're dealing with the months with 31 days, but it's 300 days, which is longer than with the EEOC, of the date of the alleged discrimination. Again, super important not to miss those deadlines, and ideally consulting with an attorney regarding your deadline and your case. And the PowerPoint does include a link to how to file a discrimination complaint with the CHRO. And we will be sharing this PowerPoint with everybody after the webinar. We really appreciate you taking the time to listen to us. If you need more help, feel free to contact either of our offices. And I will turn it back over either to Michael or Kaylee.
Yes, thank you, Kathy. We will now be taking a quick intermission, 5 minutes. So we will come back at 3:40 and start the presentation. Thank you. is now 3:40. I hope everyone is back. We're running low on time, so we're gonna get right to it. Next, we have Erin. And Erin, I'll just let you have the floor.
Thank you so much. I'm going to go ahead and share my screen. And we'll get started. Okay, so I'm Erin Choquette from the Connecticut Paid Leave Authority. I'm going to talk briefly about the FMLA and the Connecticut Paid Leave Act. Because there's a lot of information and not a lot of time, I'm really going to focus on the Connecticut Paid Leave Act, but the slide deck is much longer and will be shared with you so that you will have the information, and it includes links to our website as well as other useful links. So if you have further questions, you'll have resources. So first, we start with definitions. What is FMLA? Well, it's the Family and Medical Leave Act. There are actually two different laws. There's a federal FMLA and a Connecticut FMLA. These laws allow eligible employees to take job-protected leave from work for specific reasons. Both laws say that leave taken under FMLA is unpaid, but the employer has the ability, the option, to enact policies that allow for income replacement, either by just keeping their employees on the payroll, or by having a policy about using your vacation or sick time, or possibly by obtaining a short-term disability policy. Both laws have been on the books since the 90s, but Connecticut FMLA changed radically in January of 2022 to make it much broader. The Connecticut Paid Leave Act is a separate Connecticut law which provides a source of income replacement benefits for eligible employees who cannot work for the same reasons as FMLA. It does not provide job protection. That's a really important distinction. We provide the money, and FMLA provides the job protection. The qualifying reasons are basically the same. First, and most often used, is leave taken by a worker because they have a serious health condition. So they cannot work, they need to receive treatment, or they need to recover from that condition. And this definition includes being an organ or bone marrow donor, as well as pregnancy. Another reason to take FMLA or receive CTPL benefits is for bonding. That's when you take time away from work as a parent of a newborn or newly adopted or newly placed foster child to just build that connection, that emotional attachment to the baby or new child. Both parents can take bonding leave. The third most frequent reason is caregiver leave. This is leave taken by a worker to take care of a family member who has a serious health condition. Caring for a family member could mean actually helping with the treatment. It could mean taking the person to doctor's offices, or it could mean just being with them, providing that care and comfort that their family member needs. There are three additional reasons. There's military caregiver leave, which is specifically available if the family member is wounded in the line of duty on active duty. Then there's qualifying exigency leave, which is leave taken by a worker whose parent, spouse, or child has been deployed or called to active duty in the armed forces. There are 9 specific qualifying exigencies. They could be going to a sending off ceremony. It could be meeting with a lawyer to update your will. It could be going to a welcome home ceremony. Finally, there's the Family Violence Leave Act. Technically, this is not part of FMLA. It is a Connecticut law which says employees who are directly impacted, so the victim of family violence, can take up to 12 calendar days of unpaid leave to receive treatment, to receive counseling, to relocate, or to go to court for reasons associated with the family violence. And they can receive income replacement from CT paid leave if they need that time. One of the reasons was that caregiver leave for a family member, the definition of family member under Connecticut law changed in January, and it is much broader now. Under federal FMLA and under the old Connecticut FMLA, you could take leave to care for a parent or a spouse, or a child under 18, or a child under 18 and over who has a disability as defined by the ADA that prevents that individual from engaging in 3 or more activities of daily living. But now, under Connecticut law, you can take leave and receive income replacement benefits to care for a parent or a spouse, a son or daughter of any age, a sibling, a grandparent, a grandchild, or a person related to the employee by blood or affinity who the employee shows is the equivalent of one of those relationships. We see this most often with couples who are not married but have a long-term relationship. So they're cohabitating, they are equivalent to marriage. What should you know about Connecticut paid leave? The first thing to know is if you work for a covered employer. Almost all employers in Connecticut are covered. The definition says you have to have an employer with 1 or more people working in Connecticut. It also says the state of Connecticut is covered as to its non-union employees. Union employees will be covered only if they bargain in. The federal government, municipalities, boards of education, non-public elementary and secondary schools, railroads, governments of other states and other sovereign nations, including Mashantuckets and Mohegan, are excluded from coverage, meaning their employees do not participate in the program and cannot receive benefits. If you work for a covered employer, you are paying into the program. Our program is entirely employee funded, and it's paid through a 0.5% deduction from our paychecks, which are remitted to the authority by the employer each quarter and goes into the paid leave trust. And we use that trust to pay for the program and the benefits. The contributions are capped at the Social Security contribution limit. So if you earn more than that, you stop paying contributions on that additional money. To be eligible for benefits, you must have earned at least $2,325 in your highest earning quarter when we look at the first 4 of the 5 most recently completed quarters. You also have to be either currently working in Connecticut with a covered employer, or if not, you had been working in Connecticut for a covered employer at some point in the 12 weeks before you apply. Or if you're a sole proprietor or self-employed individual, you are not required to participate, but you can enroll. But in order to get benefits, you have to have been enrolled. The authority, my office, makes the eligibility determinations. This is done by us, not the employer. The benefit amount is set by statute, depending on how much you earn. We have a benefit calculator on our website to help you estimate what your benefit might be, which I think is just very helpful. It is an estimate because the actual calculation of benefits depends on how much leave you're taking, if you're taking a full week or something less than a week, and if your employer is providing any income replacement benefits to you. Our statute says that an employee can receive benefits from the authority and the employer at the same time, as long as the total amount does not exceed 100% of your regular wages. So you need to know, will your employer allow or require you to use your employer-provided paid time off? And what are the rules? And in particular, if you have a short-term disability policy through work, you need to get information about that policy. Many policies require you to apply to us first as a condition of being able to apply to them second. The benefits are generally available for 12 weeks in a 12-month period. For one or more leave reasons, it's 12 total, with 2 exceptions. That family violence leave is only available for 12 days. And a person who has a serious health condition during pregnancy can receive up to 2 additional weeks. Now, pregnancy is a serious health condition, so you could use those 2 weeks for bed rest, for prenatal treatments, but you could also use them if you break your leg while you're pregnant. But you can only get those 2 weeks until childbirth. You can't use it afterwards, but you still get the other 12 weeks. Applying for paid leave benefits can be done in 2 ways. First, you could apply through our website, ctpaidleave.org, and click on Submit or View Claim. You could also start your application by calling our third-party administrator at the number on the screen. Our website is available in English or Spanish, and if you call on the phone, you can choose your language. When you start your application or you call on the phone, you will do the intake. You will be then asked to provide documents to support your claim. You have to verify your employment and work schedule with a form that you give to your employer to complete. You also have to provide us with documents to verify your identity. And then there's also the document to support your reason for leave, usually a medical certificate. The employer cannot prevent you from applying for CT paid leave benefits, but you are required to notify the employer that you've applied. But it's really important to remember, we're just there for income replacement. If you need job protected leave under FMLA, you apply to your employer for that. Usually, you would start by talking to your employer about the need for leave, go through their process, which will be outlined in the materials that will be shared to you, and then apply with us. And you can use some of the same documents to make it easier. I'm going to skip through the FMLA slides right now, but you'll get them, just so I can show you a list of resources. Oops. If you have questions about the Connecticut Paid Leave Program, please check out our website at ctpaidleave.org. If you have questions about a CT paid leave claim that you've already filed, you can access your account through our portal and see its status, what documents have been submitted, or you can call AFLAC, our third-party administrator. If you have questions about Connecticut FMLA, which is the job protected leave, or if you think you were wrongly denied FMLA, or you felt retaliated against or interfered with in your ability to exercise your rights under FMLA or Connecticut paid leave, you can go to the Connecticut Department of Labor. If you have questions about federal FMLA, you would go to the US Department of Labor. I'm going to stop sharing now. And whoops, there we go. And turn it back so we can do a few minutes of questions. I don't know how you want to do that.
Erin, there had been a question in the chat whether or not bonding leave would be available for people to bond with a new service dog. And we were able to provide the answer under the ADA, but would love to hear your thoughts on what that could mean for someone under Connecticut state law.
That's a great question. And I know under the ADA, that time is a reasonable accommodation. Unfortunately, it is not a covered reason under FMLA or Connecticut paid leave. So it would not count against your usage of FMLA, those 12 weeks. And unfortunately, you could not apply to us for income replacement through our program during that time.
Thank you so much. We definitely want to invite people to put questions into the chat or to use the raise hand feature, which can be found under the reactions button at the bottom of your Zoom screen. And we will invite you to turn on your microphone if you have questions for Erin or Debbie or Kathy.
Hi, I'm Annie Dance. I have a question. Can you talk a little bit about how best practices in requesting accommodations when you are applying to a job? You know, how do you best go about that? I'm mostly deaf and I'm looking for employment. So a lot of times I see jobs that say, you know, call this number, or, you know, ways that are not exactly accessible.
And this is Kathy. I think part of it is a systemic problem. Employers should anticipate that people might need accommodations in the application process and include in the announcement. If you need a reasonable accommodation, this is how you can reach out, and include both, you know, maybe a phone number and an email that someone can reach out to. I will tell you, now that I'm in the position of being an employer, I appreciate it when people ask for what they need. You know, we put it in our job announcements now that say, make it very clear, if you need an accommodation, this is how to request it. And, you know, I know a lot of people talk about, you know, there's the whole question of, do you disclose, do you not disclose? But if it's something you need to be able to get through the process, you just have to come out, and the best way to do it is just to ask.
Yeah, I agree completely with Kathy, and you know, I'm in a similar position as Kathy, and we always invite people, you know, to ask for an accommodation, whether it's, you know, doing a webinar or in an employment or whatever they need. And so I think you should definitely just ask and be very specific about what it is that you need.
We had one question in the chat, and then I think we may be out of time. The question was, I would like to know if I am able to apply for Connecticut paid leave for my autistic child.
So most likely, yes. If your child is unable to go to school or participate in regular activities because of their medical condition, or they need medical treatment, you can apply for FMLA through your employer and benefit protection income replacement benefits through us as a caregiver to your child. Your child's doctor will need to complete a caregiver medical certification form explaining their serious health condition and your need to take time. And then, you know, you have to meet the eligibility requirements, but in general, it is a covered reason.
Thank you, Erin.
Okay, I think that was our last question for today. This ends today's presentation. I'd like to thank all of our speakers for today's discussion. I'd also like to thank all of you, our attendees, for joining us as well. So take care and enjoy the rest of your day.